Hi there, I'm Clifford Bates, and welcome once again to reading Carl Schmitt's Dictatorship. And today we finish off Dictatorship in the sense. I'm shooting from my apartment because I'm still rather ill. I got hit with COVID, that next round of COVID, whatever, blah. And you can hear my voice it's still there. So. And with this, I'm going to basically take a hiatus. I will probably continue Friday meetings for a couple of days until after Christmas. So this is just I'm going to make an announcement to the channel. So, um, so today we finish up the fifth part. I divided chapter 6, the state of siege, into basically 5 divisions. Today, this will look at pages 173 to 179, the end of the chapter and end of the book. And I'm only covering dictatorship. I'm not doing the appendixes. Sometime in the future, maybe I will do the appendixes. The appendixes are basically looking at article. It's kind of addressing some issues that are tied at this end point about the Weimar Constitution. So we have this ending point of state of siege, looking at France, looking at from the French Revolution and all to the Restoration, the first short Restoration, Napoleon's return, then the Restoration, July Monarchy, the revolutions of 1848, and this situation in France, which normalizes the state of siege as it goes from a military technical question to a political issue to therefore from a kind of a commissarial issue to in other words, the question is not that it's from a sovereign dictatorship. It turns into what he says a legal procedure, right? So let us start where we left off, right? We left off at the right of taxation. In other words, that the military chiefs were not allowed to interfere with other civil rights and liberties warranted by the Constitution, such as private property, freedom of conscience, even though they can deal with those other things in the rebellion and the suspension of Constitution of the state of siege, this new state of siege of 1830s and things onwards, from looking at the law of 9. So now he's talking about the law of 9 August 1849, right? And he turns saying here we go. It's a state of siege. Retains the existing regulation of the military stuff, but it's not that. It becomes a fiction, this idea that the political thing comes here. And it turns no longer into, he says, the provision had to make sure that certain rights were suspended at the very moment when the state of siege. So therefore, it started defining specifically what rights were going to be defined. So therefore, by normalizing the exception, what happened was that in other words, the scope, in other words, instead of being done by a exceptional commissary, it was now being done by standard ministry officers. The officers here, the military chief, right, the military head of the military, the government, the military, and that during the state of emergency of crisis, the political one, the military took over, and therefore it was not a situation of commissarial situation, but merely it was no longer the king, but the constituted assembly. So let's continue looking at this. And he goes, with this law, and it's the law here in question is the 9th August 1849 law on the state of siege, right? On the development of the state of siege, insofar as its present as it presents fundamental historic aspects, right? Comes to an end. The legislative details of later provisions need not be discussed here any further. The crucial fact is that the authorization to take an action that the given situation necessitates has been replaced. So in other words, authorization, extraordinary, the situation is a crisis and it needs to be dealt with as either a state of siege, an enemy has besieged a city or a fortification or an area, or a city has become a rebellion. that this is, in other words, a given situation necessitates. Therefore, the situation of the situation necessitates. So instead of an authorization to take action, that a given situation has been replaced by a number of limited functions. In other words, so therefore, this extraordinary thing, because the situation was extraordinary, it required certain actions to resolve it. Now, what's happening is it's no longer tied to this. So it is no longer the Constitution as a whole that is suspended, but rather several concrete constitutional liberties. Nor are these suspended without qualification, but only by naming the permissible intrusion. So therefore, in other words, what happens is that with the older conception, the previous situation, was that the extraordinary situation suspended the whole Constitution, right? That's the traditional conception of dictatorship. How this new normalized conception of this is that it's no longer just a overall suspension of the Constitution. Now it's specified, it's regulated and specified what rights are to be taken away. And if they're not specified, if these things are not specified, then it's no longer, you can't do it. It has no authorization. Therefore, it empowers executive agents to do something, but it limits it by doing it. Because the old commissarial aspect was that it was unlimited. It was to do whatever necessary be done to do it, and that you were exempt. The law exempt. The rule. This situation and this crisis gave you kind of you weren't going to be punished. The law was set aside. Here now the law is not set aside. So again, he says, nor are they suspended without qualification, but only by naming the permissible intrusions. However, the fundamental distinction between a military and a political state of siege already indicated that. In reality, the aim of this regulation was to give the military chiefs some far-reaching functions pertaining to police security that were not yet contained in the transition of executive power. So in other words, he's saying that this regulation at this point was really just kind of saying, okay, the police, the military chief, the head of the military has now these authorities in this situation, and this is what he can do, and not a kind of a broad-reaching change of power in that sense. The distinction, by contrast, direct action was not yet recorded. So therefore, this direct action is not yet recorded. And I'm suspicious by that translation there. Something's funny there. The distinction between a military and a political state of siege was discussed for the first time in 1829, together with the labeling of the latter as a fiction. So therefore, in 1829, it says that there's a distinction between an almost military state of siege and a political stage of siege. And the later one, he says, is defined as a fiction. Now, I'm going to look at the note here. I think it is. This is, again, this is just a reference note to the Reinach's state of siege. The political state of siege was called a fiction in order to express the fact that here, unlike in military operation, there was an unconditional freedom of action. So therefore, unlike the military situation, that was technical. This one, there is an unlimited freedom of action. Consequently, particular rights are removed in the beginning. The particular rights were removed in the beginning. The right to a natural judge, in other words, having a judge, someone who's a real judge in that sense. Okay, I was just a little bit of notice, and it kind of made me a little nervous. A natural judge, right? Then personal freedoms and the freedom of the press. Without concerning that the action of the military commander depended on the enemy's resistance and the nature of this combat that intervened and intervened in the life and property of political enemies. In other words, it's not. In other words, that these things in the political. In other words, here, in the political state of siege, she says that all these rights were done without consideration that the military state of siege, technical issue, required, is reacting to the enemy and responding to the enemy, to deny them the means to be able to wage war and to do things, right? To deny them and that stuff. Here, this new state of siege, a political state of siege, changes it, and it's, he says it's kind of like denies them not only the right to a judge and personal freedoms, right, without considering the actions of the military commander. In other words, the need of the military commander to do certain things. It didn't depend on the actual military situation, whereas the military state of siege kind of does. So according to the current legal conception, however, with the declaration of the state of siege, these enemies did not cease to be citizens and to have constitutionally guaranteed rights to freedom. So therefore, even though the state of siege is declared, they still are citizens and they still have certain rights under the Constitution. The military commander had to impair the civil liberties of non-participatory citizens whose persons or properties was within the scope of military action. So that's the military conception, right? In other words, that in the scope of their, their persons and their property were in the military actions being taken place. And therefore, their persons and therefore non-participatory people are going to be whose persons and property was scope. We're going to impair their civil liberties, right? Not because they were actively engaged in rebellion, but because they were just there in the middle of the situation, and that's their presence or their activities were going to hinder the military action to do something. While these frequently cruel interventions were not mentioned, the authority to suppress a newspaper was discussed and analyzed in detail, until the historic significance of what was really going on was overshadowed by agreements for police security. In other words, what was discussed was not this technique. The focus changed from focusing on regulating the military situation now, but to regulating the police situation of police security, what the police could justify and legitimately do as their role in police security. So when and how a paper could be suspended, right? And while there was an attempt to limit powers and functions of the military chief, it went without saying that the powers and functions of the Constituted Assembly, as bearer of the constituting power, right, were unlimited and not bound to constitutionally guaranteed liberties. In other words, that even though there was going to be limits to the military, what the military chief could or could not do, the Constituted Assembly, holding the constituting power, this ultimate power of the power to create, the power to make. This is the aspect of the true sovereignty, the holder of true sovereignty. The Constituted Assembly acts as this, and that they're not bound. That this assembly is no longer bound by. They're the creator of the Constitution. They are the creator of the Constitution, the creator of primary law, and therefore they are not bound by constitutionally guaranteed liberties. And therefore the decree of June 27, 1848 decided as a measure of general security, this is the par measure du secours général, as a measure of general security, the deportation of all persons who had been arrested on the grounds of participating in the insurgency. It also ordered that inquests against the leaders of insurgency should be continued through court-martial, and even after the suspension of the state of siege. Right? Let's go look at 47. Note 47. This is going to have a longer note. He goes. And he says this is the bulletin of 1848, bulletin 10-1, 1848, number 513. And also number 510, and gives the page. It also decided that the pouvoir constitute the power, the constituted power, could thereby exercise an unlimited authority through the assembly, right? Again, see, now he says 2 books about, his first, Tessa Defage's The State of Siege, and Reinhardt's The State of Siege, both for books about this. There was accordingly one place where the unlimited power could in principle appear. Now, this idea of the unlimited power, only one place under this theory of state, okay, that in the power, constituting power was the basis for this. Remember, go back all the way to the early point. But its exercise was not left to the technical, practical discretions of a military commander. This power was the prerogative of the Constituent Assembly, the Constituent Assembly. And it was delegated to the military commander only through a mandate from that assembly. Again, therefore, what happens is in other words, the military commander and his exercising of these functions was done it wasn't him exercising this absolute sovereign dictatorship power. It was rather the assembly. The Constituting Assembly was the actual dictator. It was the authority exercising sovereign dictatorship. And that what was there was that the military commander was acting under the authority of this, under statute, under provisions. Okay, so therefore, it was as he says that this power was a prerogative of the Constituent Assembly, and it was delegated to military commander only through a mandate from this assembly. Dictatorship, which was so much talked about, was no dictatorship of the military leader. It was rather a case of sovereign dictatorship exercised by the Constituted Assembly. The military leader was a commissarial appointee. Okay, end of paragraph. Now, he goes, he's going to say now, in Roman law, as well as the literature of non-natural law, as well as in Locke, an uncompromising representative of the Reichstag, right? No, this is that line he loves to say. Locke is the father of the uncompromised of the legal state, or the Reichstag. The right over life and death appears as most important expression of an unlimited authority. Remember this. So that in both in Roman law, the natural law writers, and Locke, this emergency power, this emergency prerogative power, and Locke it's called prerogative, right? This emergency power that has to be done is over life and death, public safety, right? The need for the public's benefit, public safety. The right of life and death appeared most important as the unlimited authority. But in the 19th century, when dictatorship was mentioned, one understood by it the so-called fictional state of siege. When one tried to capture the legal concept of dictatorship, the discussion turned to topics such as freedom of the press, but not to the countless people who had lost their lives. In reality, and not just in fiction, on the two sides of a civil war. So therefore, this is when 19th century, this discussion of the state of siege, right, this fictional state of siege, and the concept of dictatorship in light of the situation. The question of life and death wasn't the issue of concern, but rather what? The question of things like freedom of the press and other rights in that sense were functional. Property, right? He continues, and not to the deaths of people involved in the civil in two sides of the Civil War. He goes, this state of things was due to a particular incapacity to distinguish between the contents of a commission of action and a legally regulated procedure. So therefore, what happens is blurring. Instead of an understanding of a situation this is a content of a commission of action, an extraordinary commission of action, as we discussed earlier in the earlier books of the dictatorship, right? That comes all the way at the beginning of church history in the early times of the Middle Ages. This extraordinary emergency commission to do something, to do some action, right? Versus it becomes the inability. The legal system is distinguish between this commission of action and a legally regulated procedure. We could perhaps be excused if, For the sake of illustrating and clarifying this distinction, we shall anticipate a debate that took place elsewhere and refer to Article 48 of the German Constitution of 11th August 1919, which regulates the state of exception. So you're going to say, look at Article 48 and look at the Article 48 state of exception, right, in the German Constitution, Weimar Constitution. Now, this is his shift to Weimar at the end. He's now linking the state of siege issue problem and the way the French handled it in terms of this shift from an extraordinary commission to a as he says, a legally regulated procedure. Okay, and therefore this Article 48 kind of does this through the concept of the state of exception, right? He goes. We shall do this because Article 48's provisions concerning the state of exception illuminates its historic developments in as much as they cannot be understood without this development. In other words, you can't understand what happened in this creation of this without understanding the development of this concept of the state of this move from an exceptional commission to a commission of action to a normalized procedure, a function of procedure. According to paragraph 2 of this article, of Article 48, when public security and order were constantly disturbed or threatened in the German Reich, the president can take the measure needed to restore them, and if necessary, he can be assisted by armed forces. Here lies the authorization for the commission of action unlimited by law. The president himself decides the conditions in which it should take place, although he does so under the control of the Reichstag, as regulated in paragraph 3 and in Article 50. And its actual execution has to be carried out by a commissioned body. So in other words, the president decides, and it is the president then uses the army, the commissioned body, to or the army and the police, the commissioned bodies, to execute to be carried out. In other words, the actual execution of what has been done, the situation of restoring order, has given. It was, in other words, his authority to do so is defined by the article. And that he decides what if the condition requires it. And that, although it's not absolute, he's being regulated. He's overseen by the Reichstag and is regulated by the Reichstag in that sense. So this clause, indeed, or accords a clear case of a commissarial dictatorship, an authorization for unconditional action that is certainly unusual according to the legal conception of the state so far. In other words, the legal conception of the state, this aspect. If one regards it as a automatic valid right, without waiting for the law on the state of exception, which is envisioned in paragraph 5, but still needs to be enacted. So therefore, in other words, it's a right that requires this triggering mechanism, the state of exception. In other words, this state of exception, right, which is envisioned in paragraph 5, but still needs to be envisioned. So the president of the Reich can take, in other words, this power of this commissarial, taking a commissarial dictatorship in terms of a commissar of action, right, is a valid. It is a right that he has under this article, and that he decides whether it is necessary or not. In that sense, even though he's being regulated or overseen through the Reichstag on this regard, right? So he says that the president of the Reich can take. The president of the Reich can then take all the necessary measures when, in his judgment, they are necessitated by the concrete circumstances. So again, the law specifies how, when, and who decides it, and to what degree he can exercise power, right? So it's given to him to decide the situation, and he's given the authority to resolve it, right? In other words, the president can take all the necessary measures that they restrain to necessitated by the concrete circumstances. Therefore, he can also, as the Reich Minister of Justice Eugene Schleifer admitted in the Constitutional Assembly, use poison gas against cities if, in the given case, this is the necessary measure for the restoration of security and order. Right. So therefore, that's this idea, and this is 48. Again, this is in the session, this testimony. You can even use poison gas. In other words, that the situation requires it. That this aspect of this, there is no restriction, just as there's no hints as to what one needs in order to accomplish an end in a given concrete situation. But one must bear in mind that if this unlimited authorization should not signal the dissolution of the entire existing legal system and the transfer of sovereignty to the President of the Reich, in other words, it dissolves the entire existing legal system and the transfer of sovereignty to the President of the Reich. These measures are always no more than concrete ones, such as such, they are neither acts of legislation nor acts of judicature. So therefore, in other words, these acts of the presidential right are merely acts of the situation, not acts of legislation, nor acts of a judge in this, adjudication in that sense, judicature. Schrieffer, the Reich Minister of Justice, concluded from here that in Article 48, no specific restriction is defined and that the empowerment is unlimited. So again, Article 48, no specific restrictions are defined and the empowerment is unlimited. But the conclusion itself applies only to the concrete measures. Where the legislature and the administration of justice are concerned, it only applies to positive provisions of the Constitution, as the minister assumed them to be, invoking comments made by the correspondent Stillbook and Count of Dona in the session of July 5th, 1919. The intervention into the sphere of constitutionally guaranteed freedoms is always of a concrete nature. In other words, he stops here. He says that the intervention into the spheres of constitutional guarantees is always a concrete one. Should every arbitrary act of the legislature also come under the general fiat? In other words, should every arbitrary act of the legislature also come under the fiat of Article 48, then this article would amount to an unlimited delegation, and it is inconsistent to claim that this would not suspend the Constitution. In other words, he's saying that, okay, but given this and given how the structure of the law works, wait a minute, what about the acts of the legislature? Should every arbitrary act of the legislature also, because given that he's saying that it's an arbitrary act, it's always a situation. In other words, and he says that all constitutional violations are always concrete situational things, he's saying. So the intervention in the sphere of Constitution guaranteed freedoms is always of concrete nature. And therefore, in other words, he goes to that line, he says, should the legislature also come under the general fiat of Article 48, then this article would amount to an unlimited delegation and is inconsistent with the claim that this would not suspend the Constitution. The interpretation that the monarchy of the Restoration gave Article 14 of the French Constitution of 1814 suspended that Constitution in exactly the same way. Right, so he points to the Restoration, the monarchy of the Restoration in France, and particularly Article 14 of the French Constitution of 1814, argued that this provision, this idea of this emergency state of siege, suspended the Constitution the same way as this. He's saying that could happen under Article 48, even the legislature in a sense. The only difference is that in that case, the king claimed a sovereignty understood as an extraordinary and unlimited plenitude of powers. Whereas now, the president of the Reich, or rather the parliament, in view of the controls it has over him, decides an unlimited scope of unlimited state of exception. So therefore, what was a claim of unlimited power? The king, when he was exercising this act, was exercising a sovereignty, claimed sovereignty, understood as an extraordinary and unlimited plenitude of powers, right? Now it's not that; it's rather that this is the president of the Reich, or the parliament, because remember the parliament has control over him in this sense, decides the unlimited state of exception. Therefore, the president or the Reichstag would become the bearer of a constituting power, and the Constitution would remain a precarious and provisional arrangement, being part of a constituted order. In other words, he's saying that by giving them this in the state of emergency and deciding what can be accepted and what cannot be accepted. Now, this has now changed. That the president or the Reichstag would now be the holder of the pouvoir constituant, the constituting power, the power to make in that sense, right? And the Constitution remain a precarious and provisional arrangement as being, because remember the Constitution. In other words, the Constitution and the Constitution and all the powers and provisions it has is a constituted thing. Remember what he said. The pouvoir constituant, the constituting power, is the creating power. It is the creator, and the Constitution is the created. This goes back all the way back in the earlier chapters where he makes this distinction between that which is creating and that is created. The president of the Reich could accept such authority on the basis of a mandate from the constituted National Assembly, and if one is to view its members as bearers of a constituting pouvoir constituting, the constituting power, and the president as their commissar. So therefore, in other words, that the president of the Reich could accept this authority on the basis of a mandate from this. If one viewed that the constituted National Assembly is and its members are the ones holding this constituting power. Remember, they're the ones who create the Constitution. It is this convening assembly, the assembly of the Reich in that sense. So now we continue this problem. Such a construction would be conceivable according to the constitutional law of Western European states. In other words, this logic is the logic of the constitutional law of the Western states, right? Of their Reichstag, their Stadtler, their state theory, right? The result would be, however, that his mandate comes to an end when the establishment of the National Assembly. So once you create an establishment of National Assembly, by contrast, the Reichstag would not be the Reichstag would certainly not be in a position to mandate unlimited commissions, since it is a constituted power. So, in other words, ironically, it's this. In other words, it's the constituted National Assembly that has the power to do this. So, there's a difference between the constituted National Assembly versus the Reichstag, which is a constituted power, right? That's the whole point. That goes all the way back to the earlier sections. The contradiction implicit in this positive regulation of Article 48 becomes apparent, again, under the impact of historic developments along this line and in the aftermath of general empowerment to action. The article itself stipulates further that for this purpose, namely for the restoration of the public security and order. The President of the Reich is entitled temporarily to suspend, completely or in part, the following basic rights adopted in the following articles of legislation, and the period of time is not sufficiently defined. And what are they? Personal freedoms, Article 114, domiciliary rights, Article 115, rights of letters and posts, Article 117, freedoms of the press and censorship, Article 118, freedom of assembly, Article 123, freedom of association, Article 124, and private property, Article 153. In contrast to the unlimited powers granted in the previous sentence, the powers here is limited through the listing of those basic rights that can be interfered with. In other words, in contrast to those to the unlimited power granted in the previous sentence, the powers here is limited through the listing of those basic rights. So therefore, at first, there's unlimited power, but then he limits it by listing the rights, right? According to the previous analysis, the enumeration does not indicate a delegation of legislative power. In other words, by enumerating, this does not delegate all legislative power, but only an authorization to concrete action, on the strength of which obstructing rights can be disregarded in concrete cases. So it's not giving to the executive legislative power. It's only saying, well, if these rights can be authorization. In other words, these rights, which are seen to be obstructing rights, which obstructing rights can be disregarded in the concrete case. The basic rights are listed, however, numerous, and their contents is so general that the authorization is barely circumscribed, although it is missing. For example, in Article 159, right? In other words, their context is so general in that their authorization is barely circumscribed, although it's missing. For example, in Article 159, nevertheless, to grant first an authorization on the basis of which the entire established legal situation can be suspended, including, for example, Article 159, and then to list a certain number of fundamental rights that can be suspended, remains a peculiar regulation. In other words, he's saying that all rights can be then listing them. He says this is okay, peculiar. It is absurd to reassure the president of the Reich that he can allow the public authorities to ban newspapers when he can theoretically advance against cities with poison gas and threaten death penalty, or to allow extraordinary commissions to impose it. So it's absurd, he says it's absurd to reassure the president that he can authorize that ban newspapers, right? When theoretically he can go to war with the society, use poison gas and threaten death penalty, or to allow extraordinary commissions to impose it, right? The right over life and death is implicit. It is implicit here. The right to suspend the freedom of the press is spelled out, explicit. So implicit. In other words, the right of life and death is implicit. Explicit. In other words, the right to suspend the freedom of press is spelled out. So this is the absurdity of the situation, and I think this is why maybe reading. Go look at the Schmitt's my previous videos on Schmitt's legality and legitimization. Schmitt on legality and legitimization, where he deals with this problem more explicitly in that sense, right? These contradictions are not conspicuous in the German Constitution of 18. In other words, so those constitutions are not conspicuous in the German Constitution of 1919 because they are the result of a combination of sovereign and commissarial dictatorship, and therefore they are parallel to the entire development into which this confusion is implicitly contained. So therefore, these contradictions are not conspicuous. They're not conspicuous in this in the Constitution because they're the results of a combination of sovereign and commissarial dictatorship. In that sense, it's blending of it, blurring of it. Because remember, the Reichspräsident is commissarial and that's exercising of it, whereas the Constituent Assembly is sovereign. So this blurring of these two things. And there is only one explanation for the remarkable circumstances that this development is the development is dominated in its entirety. In other words, there is only one explanation for this remarkable circumstance, that the development is dominated in its entirety. In the transition from princely absolutism to civil legal state, it is taken for granted that the solid unity of the state had first been secured. So it's always guaranteed this movement from princely absolutism to civil state. It always taken for granted that the solid unity of the state has been first secured. Tumults and riots could disturb the security, but the homogeneity of the state would not be seriously threatened by social factions within it. This is always assumed. If an individual or group of individuals is to disturb the legal order, this is an action whose counteraction can be calculated and regulated in advance. Just as the civil and criminal procedural execution defines the precision and scope of its instruments of power, and that is the legal regulation of its procedures. In other words, he's making an analogy here. He goes, in other words, the assumption of this transition of this, that power, that what, this is going to be transferred here, it's assumed that this is not, and that factional disputes and this stuff is like criminal activity. In other words, political disputes and factional things are nothing different than criminal activity in a sense. And therefore, it doesn't really threaten in other words, the logic of the state is not just undone by this. This is rather than it's merely just there's, people breaking the law, people not doing things properly. So therefore, this is why if an individual or a group of individuals disturb the legal order, he says, keep repeating this, this is an action whose counteraction can be calculated and regulated in advance. And again, he says, well, in the same way that we understand laws being broken in advance, right? Civil procedures, civil and criminal procedures, right? And then, therefore, whose execution, procedural execution defines with precision the scope of its instruments of power, and that legal regulations of its procedure, in other words, law, regulatory, criminal law, civil law. In other words, that this is now going to be done by regulation in a sense. We go from an extraordinary commission to a normalized regulation, right? It may be that the goal, to be achieved is jeopardized by such limitation. In other words, he's saying that the goal. It may be that the goal that you need to achieve, the security of the regime, might be jeopardized by these limitations, these procedures, this kind of, because you can't know in advance. In other words, he's saying in that sense, maybe, right? When the accredited measures of execution are exhausted, the coercion of the guilty fails. So what happens when the accredited measures of executions are exhausted and the coercion of the guilty fails? Binding those strong sense of whose strong sense of justice must have been most outraged by this, expressed is thus: the guilty ridicules the right. Right, the guilty. In other words, that the guilty people are. This is the problem with the law. All the criminals break the law, and the laws are broken, and the law can't respond. It cannot coerce. In other words, the law, the measures of execution are exhausted, and the criminals are still doing it, right? And that the coercion of the guilty is not working. The amount of coercion being necessary, that the guilty is still doing it. So what happens? Those who have the sense of justice are going to be saying, what? The guilty ridicules justice. The guilty, those who are doing these things, ridicule justice. But this ridicule does not threaten the unity of the state and the existence of the legal order, he's saying. But usually this ridicule of the criminal that does not threaten the state, and the argument is the unity of the state. and the existence of the execution. The execution can be regulated according to a legal procedure, as long as the enemy is not a power that throws into question that unity. Now, this is the very important thing. He says that as long, the criminality and these things, we can tolerate these because these things are not going to destroy the unity of the state. But the second the criminal enemy are not the enemy, that the enemy becomes what? As long as the enemy is not a power that throws into question the unity of the state body. That was the historical value of the absolute monarchy, or at least for the constitutional liberalism of the 18th and 19th century continental Europe. It destroyed the feudal powers and the powers of the estates, and by doing so, it created a sovereignty in the modern sense of the unity of the state. The endeavor of isolating the individual and eliminating any social groups within the state so that the individual and the state may stand in opposition to each other was emphasized in the exposition concerning the theory behind legal despotism and behind the contract social, social contract, the contract social, right? In other words, you don't want other powers. You only want the state and the people. You don't want intermediating. In other words, this whole move of this 18th and 19th century liberalism was to destroy the intermediary bodies and only to have the citizen in relation to the state, right? In this sense, the endeavor of isolating the individual and eliminating any social group within the state so that the individual and the state may stand in opposition to each other with what was emphasized in the exposition concerning the theory behind legal despotism, the Enlightenment period. Now, this is earlier chapters, 16th and 17th, 16th and 17th century, the French, that before, two chapters before, right? And the behind the social contract, the contract social. In his speech on the Republic, Concordant, who here as well as the soul of his time, declared why he had ceased to be a monarchist and became a republican. Let's look at 49. This speech explains the legislative practice of right of association, as well as the numerous, as well as the tremendous applications of the freedom of the press as a guarantee to the guarantee of unimpeded public opinion, which, as it is said, should be the best way to control the government. If there had ever been one newspaper, say Concordant, then Cromwell had not been Lord Protector. The fact that control means political power, and hence it instantly generates the problem of organizing this power, was still completely alien to Concordant. Now he's mocking Concordant, and I think they should mock Concordant in this thing, because he's right in that this idea of unlimited freedom of the press in that sense. He goes that this is why Concordant said he ceased to be a monarchist. Until we are no longer living in a time of powerful groups and classes within the state, the association powerful associations have disappeared. In other words, the destruction of this. As long as they existed, the armed despotism was, in other words, an armed despotism. In other words, as long as these powerful associations exist, Concordant argued that they existed. An armed despotism was needed in order to keep them down, right? So therefore, this idea of balancing power, that these associations, these powerful associations, as long as they existed, in other words, you needed to balance. And I think this is where Concordant, we can argue that the problem with liberalism is that Concordant and his theory of liberalism is, well, if you have all these powerful, but the problem is, what happens if you can't? What happens? These intermediate powers can never be truly undermined. And the state can never be that powerful that it can destroy those forces. See, that's the problem. This is that, and therefore the reason why the other system needed that powerful state. In other words, you needed an armed despotism to control that, because these forces were destructive of liberty and people's freedom. And therefore, if you destroy that by regulating it and ruling, saying we don't need it anymore, therefore we don't need it. Now he says what? Today, on the other hand, individuals, isolated as they are through the equality of all, confronts a uniform collectivity. Confronts a uniform collectivity. One needs only a few instruments of power. Machtmittel, right? Instruments of power, to force them into obedience. In fact, being okay. This is the French. I think that is the translation, literally, of that. Hold on, let me just. Sorry. It takes little force to enforce individuals into obedience, right? As that, this is the French of that line. If this is really true, then one can also regulate the so-called political state of siege, just as in a civil or criminal procedural action. In other words, you can just make it, regularize it, normalize it. The political state of siege is just as normalized as the regulatory. And maybe this is what the administrative state does in that sense. Maybe this is what the administrative state does. It takes a means to normalize this in that sense. What should be a difference between the political and the criminal now becomes the same thing, and it criminalizes the political. Right? You can see this. We can look at this. We can look at this as the way how the Biden administration and Democrats have, even Obama. Even starting with Clinton, used governmental authorities like the FBI to punish their enemies. You can say maybe even Dick Nixon, even FDR, right? That their argument was that federal agencies and criminal entities. Well, it became more. It was always present. Political leaders did use these mechanisms to oppose their enemies, but it was less present. Now what happens is the administrative entity now uses law, treats political disputes as legal disputes. And therefore, so one can outline the instruments of execution and thereby establish guarantees of civil liberty, the argument goes, right? Then the state of siege is indeed fictional, right? In this situation, it's fictional. It's not really a real thing. It's always that, even though it's extreme situation, it's not. This is how you can say the state of siege is fictional, because it's now different. It's only merely now the execution of legal provisions. In other words, what was before political and therefore extra legal now becomes same. It is treated as merely criminal in that sense, right? But if this is not true, then the powerful associations will emerge again in the state, and the whole system will collapse as a result. So this is Schmitt's point, that if this is not true, if this doesn't destroy everything, in other words, if this does not lead us to either the state and the individual, right, and public opinion can do everything like this, and therefore you can regulate this. But if that's not true, that there can be association, that people can band together and form groups that become associational, then powerful associations will emerge again in the state, and the whole system will collapse. In the year 1832 and 1848, which constitutes the most important dates in the development of the concept of the state of siege towards a legal institute, in other words, this development of the concept of the state of siege into a legal institution, the question arose concurrently whether the political organization of the proletariat and the counteraction to it had not created a completely new political situation, and together with it, new concepts of constitutional law. In other words, didn't the nature of state change? Didn't the rise of the proletarians' association with each other, the revolutionary moment, create a situation that changed the normal situation? That there were these forces that became association because tied to ideology, you say, right? And they became movements, political movements, mass political movements. and that because there was no intermediary bodies to restrain them, now that therefore they became a means by which could threaten the state order, right? And this is why this is important. So this is how he ends. Therefore, this is why the question ends this paragraph. In other words, didn't the situation that there arose revolutionary, these political organizations, proletariat, and the counteractions to them create a new situation? And therefore new concepts in constitutional law. That's that German word, Verständigkeit. Okay. Nevertheless, the concept of dictatorship, as it was formulated in the claims of the dictator of the proletariat, right? In other words, as it was formulated in the claims of the dictatorship of proletariat, was already available in its theoretical specificity. Now, please go read, go see the video, my video, when I did Schmitt's parliamentary book and the chapter on the Marxist doctrines of dictatorship. This can expand on this point here. He goes that, in other words, it was already available in the theory of this concept of dictatorship of proletariat. In the beginnings, as one might expect, the idea adapted by Marx and Engels made use only of the political catchphrase common at the time. It had been used since 1830 to label different peoples and abstractions. One talked about the dictatorships of Lafayette or of the Cavaignacs or of Napoleon III, just as one talked about the dictatorship of government or of the streets or of the press or of the capital or of the bureaucracy. In other words, it was used as kind of a catchphrase of those exercising power, right? It was used as a kind of as he says here, let's go look, I'm going to go back here. He says, in other words, when Marx used this catchphrase, it was a label. It was used as a label of different peoples. One talked about Lafayette's or Condillacs, people of exercising power, Napoleon III. As one talked about dictatorship of the government, right, or of the streets, exercising of power in that sense, right? But a tradition starting from Babeuf and Bunarati, leading up to Blanqui, had also passed on a clear idea from 1793 until 1848, and not just as a sum of political experiences and methods. In other words, this idea of dictatorship, in other words, this transition, starting with these authors, Babeuf, Bonacci, and leading up to Blanqui, has passed on a clear idea from 1793 into 1848, and not just a sum of political experiences and methods. It must be left to a separate investigation to show how the concepts developed in systematic correlation with the philosophy of the 19th century and in the political context of the experiences of the First World War. In other words, it has to be left to somebody else. In other words, he says that it must be left, this whole question of how does this become a real idea, this concept of this new situation in that sense. But a tradition starting from these authors, right, led to a clear idea until this, from this period. It is not just merely a sum of political experiences. Now, but this must be left to a separate investigation to show how this concept developed. In systemic correlation with the philosophy of the 19th century and in the political context of the experiences of the First World War. But at this point, one may indicate that from the perspective of a general theory of the state, right, in other words, Stadler, and perspective of Stadler, the dictatorship of the proletariat identified with the people at large. So therefore, from a general, in other words, we must understand, from the general theory of the state, right, the Stadler of the time, the dictatorship, in other words, the dictatorship of proletariat identified with the people in large, in transition from an economic situation in which the state is withering away, presupposing the concept of sovereign dictatorship. just in the form it stands at the root of the theory and practice of the National Convention, right? This is back all the way, the idea of the National Convention, French Revolution, right? Therefore, this is the, in other words, what he's saying, that the dictatorship of the proletariat was merely the people, and that the people was acting as the sovereign dictator in the same way the National Convention did at the beginning of this point. What Engels required for his praxis in his address to the Leagues of Communists in March 1850 was held for a political theory of the state of this transition to statelessness, right? This Staatlogikkeit. It was the same situation as in France as 1793, right? In other words, there was echo. There was the thing that he says, the praxis, that was required for the praxis, in his address to that, also held that the political theory of the state of this transition to statelessness was the same situation as in France 1793. And here ends Dictatorship. So hi there. Now, if you have any comments, questions, please put them there. And I hope we'll all see you guys when we come back. Well, I'll be doing, I hope when I return, I will do, starting in the new year, I will do Aristotle's Ethics. I think we'll go through the Ethics chapter by chapter. I'm going to take a little break and recover from whatever this is and survive and hope for the new year, get strength to do these things. So if you have any comments, questions, please put them below. I will respond to them, and I will put comments back and respond to anyone who does it. If you like it. Please hit the like button, share it with friends, share it in social media, spread the news. If you've not subscribed, subscribe. Let's grow the channel some. If you didn't like it, you can always hit the thumbs down, but say why in the comments. What's wrong, and what can we do better? Another thing you can do here is you want to follow me on social media, the links are below. And I also have my academic social media. Below them are my academic social media links about my publications and where my scholarship in that sense. Things about me as a teacher in that sense. Who knows? Might be in transition. We'll see what happens. And then another thing you can do is you want to help me to do what I do and help contribute. It'd be nice. Because life is complex and situations change, and being canceled is always a possibility these days. It would be nice. You can do so by subscribe to our Patreon. Or another way you can help is to buy one of my books that you can buy on the list of the books below through a bookstore or Amazon or any online server or your local bookstore. So there it is. That's how you can help. It would be nice if you bought the Lulu book through Lulu, because that way I get the money directly. Otherwise, the money just, I may get the money eventually, but who never sees it. Well, that's it. I hope you enjoyed this, and I will continue doing my Fridays things. I hope so during this. I might not do it tomorrow. I'll see how I feel tomorrow in that sense. Okay, take care. Bye-bye. Have a good day. And see you in the new year. Bye-bye.